Welcome back to the Financial Literacy Project, presented by the American Bar Association Tort Trial and Insurance Practice Section and Thomson Reuters. This is the fourth segment of the Understanding and Managing Debt module. In the prior video, we covered credit and FICO scores and discussed the importance of credit scores and how credit scores are determined. In this segment, we'll cover debt collections and your rights during the debt collection process. Please read our legal disclaimer in full. In sum, these materials and forms referenced are for educational and informational purposes only. State and federal laws can protect you when you have debt. The federal law is the Fair Debt Collection Practices Act, FDCPA. State laws depend on what state you are in. For example, in California, we have the California Rosenthal Fair Debt Collection Practices Act. These laws tell debt collectors what they can and cannot do while trying to collect from you. A debt collector cannot charge additional costs and fees to your debt unless that is allowed by the contract or a law. Deposit a post-dated check before the date on the check. Communicate with you using postcards. Use language or symbols on correspondence envelopes other than the address that indicate that the letter is from a debt collector, threaten to arrest you, or threaten to do anything that they are not legally able to do or that they know they have no intention of doing. If you are contacted by a debt collector, never provide your private information, such as your social security number, bank account, or birthday, over the phone. If the collection agency does anything you think violates your rights, contact the Consumer Financial Protection Bureau or CFPB to file a complaint at www.consumerfinance.gov. Here are some steps you can take to manage your debt. Before you miss a payment, contact the creditor and ask about forbearance agreements or payment arrangements. Contact a nonprofit credit counseling agency. After you miss your first payment, find a nonprofit credit counseling agency to help you make a debt management plan. If you have a small number of creditors and small balances, you may want to do a lump sum settlement. Another option you can discuss with a nonprofit credit counseling agency is to wait and see. Some creditors will not take action to collect. In that case, you will need to be prepared to defend a lawsuit. However, not all creditors file lawsuits, but many collection agencies do. It's very important to open your mail so you don't miss any notices. In civil litigation, if a lawsuit is filed, you need to defend it. Check your court for your local rules, timelines, and forms to help you. There is a limited time to answer a complaint. It can be between 20 and 30 days only. Consult your local legal aid to see if they can help. Generally, an answer must include certain defenses. Inability to pay is not a defense. Some defenses may be the statute of limitations, whether the lawsuit was filed timely, standing, whether the people who filed it are the right people under the law to collect from you, or insufficient facts to constitute a claim, meaning whether the complaint showed facts required by law to demonstrate that you are required to pay, and equitable defenses. After the summons and complaint are filed, they are served. In some states, other documents must be served too, like an alternative dispute resolution packet. Next, you file the answer within 30 days of receiving the summons and complaint. The time may vary state to state. Next, the court will schedule hearings and you can begin discovery conducted by plaintiff or defendant. That may include deposition, interrogatories, requests for admission, requests for production of documents, and other items. If the case is not resolved, it will get set for trial. If no answer is filed, then the plaintiff may request a default judgment from the court. If you do nothing, that is likely to be granted. Either side can file motions. If the other side presents evidence you think they should not be able to present, you can ask the judge to not consider the evidence. You can also demand a bill of particulars, which is a request for the other side to provide specific evidence to be presented at trial. There are specific timelines to serving and demanding. You may be able to negotiate settlements to this type of lawsuit. Typically, there are three options. A lump sum settlement is when a lump sum of money, usually less than the full balance owed, is agreed on and paid to resolve it in full. A payment plan is usually a monthly payment plan, usually for the full amount owed, including cost and fees, or a payment plan for less than the full amount owed. If you are negotiating a settlement, make sure all agreements are in writing. Do not agree to a settlement if you cannot afford to pay. Review your budget and make sure you are agreeing to terms that you can meet. And consult a nonprofit on tax or benefit consequences. For example, the amount forgiven or canceled is considered taxable income and can affect your benefits like Medicaid and Social Security. If a judgment is entered for the plaintiff, the defendant can do a number of things to collect on the judgment. Wage garnishment. The creditor can take up to 25 or 50% of a wage earner's wages above state protections. Bank levy. The creditor can seize money in a debtor's bank account over state and federal protections. Property lien. A creditor can put a lien on a debtor's property, real or personal, or prospective real property. Third-party claims. A creditor can attempt to collect on any account on which a debtor is listed, including accounts for debtor's child where a debtor is the guardian, or accounts for a debtor's elderly parent where the debtor is also an authorized signer. Alright, that concludes this segment. We hope you have a general understanding now of debt collection and your rights during the debt collection process. In the next segment, we will cover debt consolidation, including student loans.